Today I want to talk about an issue that a lot of people aren't aware of when they start a business, and that is who owns the intellectual property that's created before a limited liability company or a corporation is actually formed. Let's say you have, for example, a software engineer who has an idea for a mobile application, and she codes that mobile application in her own time at home at night, using her own resources, her own laptop. When it comes time to commercialize the application, she would like to have an investor come in to provide some money so that they can do some advertising and maybe take it to the next level. When the investor is about to come in, they decide to form a limited liability company. They do that, they file all the proper documents, sign the operating agreement, and they're off and running. So the question is, does the LLC automatically obtain ownership of the software application when they form the LLC? Or does somebody else own the intellectual property to the software application? Well, the default rule is that the person who creates the software application is going to own the copyright to it. So the software engineer, when she's coding and creating, is also creating the copyright that she'll own in that software application. That copyright isn't automatically transferred to the limited liability company when they start the business. If they start the limited liability company without thinking about this issue and without addressing it, then the software engineer is going to continue to own the copyright to the software application. That's probably not what the investor wants. It's probably not what somebody might want in the future as well if they want to buy into the company or buy the company. But how do you handle that? How do you resolve that particular issue? Well, somehow the limited liability company needs to get the rights to the software application. There are two ways that could happen. One is that the software engineer could transfer the copyright, the ownership of the copyright, into the LLC. Or if for whatever reason, if the software engineer wants to continue to own the copyright to the software application, then there should at least be a license agreement between the software engineer and the LLC. The real resolution is that you need a legal document that transfers all or some of the rights to the intellectual property into the limited liability company. And that document needs to be in writing, needs to have the right language in it, needs to be signed by the right people. And when that happens, then the LLC will then have the rights to the software application. If the software engineer and the investor are aware of this issue before they form the limited liability company, they might set up a deal by which the investor injects their capital, their cash, into the LLC in exchange for his or her ownership, and the software engineer transfers her copyright into the LLC in exchange for her ownership in the LLC. Sometimes this issue is discovered later and can be resolved later if everybody's in agreement. But again, you'll need that written legal document to either transfer all of the copyright to the software application into the LLC or to license the rights to the software application into the LLC. I'm Joel Linkney. I'm a lawyer who helps people start, run, buy, and sell small businesses. And many times those deals, those transactions involved intellectual property ownership issues. If you have a question about intellectual property creation, rights, ownership issues, or starting a small business, you can contact me by visiting my website. Stay tuned for more videos from me to answer questions that people frequently ask me about starting, running, buying, and selling a small business, or buying, selling, or leasing commercial real estate.